Well, I hope that was helpful to you. So remember, queue for questions. If you have questions, put that in the Q&A icon. And if you have comments, put that in the chat feature. So we are also recording this presentation. In the coming days, you'll be able to view it on AARP Ohio's YouTube page. We'll put that link in chat for you as well. AARP is a nonprofit, nonpartisan member organization, has been working to promote the health and well-being of older Americans for 65 years. So let me take this opportunity to share with you what AARP Ohio is doing as it relates to the financial impact of housing issues. We're working with the Ohio legislature to provide targeted relief from property taxes that have skyrocketed from the rise in property values throughout the state. Those taxes, while critical to the well-being of our communities and the funding of vital services, can be a significant financial burden when calculated on the assessed value of the residential property and not on one's ability to pay. AARP Ohio supports property tax relief that is equitable, cost-effective, and targeted to homeowners who are most financially burdened by their property tax bill, such as circuit breaker programs and property tax deferrals. Property tax circuit breakers reduce taxes for residents when the taxes exceed a certain percentage of income, while property tax deferrals allow seniors to defer paying their property taxes until the property is sold or the estate settled. To stay up to date on AARP Ohio's advocacy regarding this issue, visit aarp.org/Ohio. That's aarp.org/Ohio. Finally, AARP Money Map is a free resource that can help you take charge of your finances, from setting a financial goal to saving for retirement, to debt reduction, to managing unexpected expenses. AARP Money Map does not require membership. So to establish and save your Money Map saving plans, go to moneymap.aarp.org. moneymap.aarp.org. And again, we will put these links in the chat for you. Now, it's my pleasure to introduce you to today's speaker, Stacy Purcell. Stacy is the staff attorney at Legal Aid Society of Southwest Ohio. Stacy represents low-income homeowners who are at risk of losing their homes due to mortgage or property tax foreclosures. She is a graduate of Notre Dame Law School and Williams College. Stacy, welcome.
Hi, Nicole. Thank you for having me this evening. So I am going to go ahead and share my screen. And we are going to get into the presentation today. I feel really grateful that you all have chosen to spend part of your Wednesday evening with us here today to talk about Tangled title. I want to give a roadmap first of where we'll be going. I'm going to explain what do I mean by Tangled title, what is it, and how are they created, why Tangled titles are a problem, what to do if you think that you have a Tangled title, both how to fix it if that is possible, and if it's not possible at this time, some suggestions about how you can live with a Tangled title. And then finally, how to prevent Tangled titles from happening in the first place. Now, before we get into the heart of it, I am a lawyer, so I have to give a quick disclaimer. This presentation is not intended to be individual legal advice. This is for information only. If you think that this is an issue that is going to affect you directly, I encourage you to reach out to an attorney in your area. If you can't afford an attorney, I would look for your local legal aid organization. So for those of you that are based here in Cincinnati, Legal Aid Society of Southwest Ohio and Greater Cincinnati is your legal aid organization. You will also, if you search, be able to find legal aids throughout the country. I am an attorney in Ohio, which means I practice under Ohio law. So some of this material may be specific to Ohio. I know that we have friends joining us from across the country, so I will do my best to highlight when something might be Ohio specific and when it applies generally. If I don't say so, assume that it applies generally. But again, this goes back to that first disclaimer that you want to seek individual legal advice before taking any action for your specific situation. So what is tangled title? This is a term that is thrown around fairly frequently, but it is not a specific legal term of art. What I say is the simplest way to explain a tangled title is it occurs when property ownership is divided among multiple people or when the owner of a property is deceased. You might also hear tangled title called heirs property. That is another way to talk about the same thing. And the bottom line, and this goes to a little bit of why this is a problem, is a tangled title happens when the person who is acting as the homeowner does not have clean title to the property. So the opposite of a tangled title would be a clean title or a clear title. That's a situation where the person who is the homeowner living at the property, acting as the homeowner in all regards, is also the person whose name is on the deed. When we're talking about tangled title, we are almost exclusively going to be talking tonight about titles to homes. And in my practice, we are primarily concerned with the homes that you're living in, so your primary residence. There may be title problems that arise if you have a second home, a vacation home, that will likely be applicable to what we're talking about. But when we're talking about some of the solutions or living with tangled title, those may be geared towards primary residences. Now, tangled titles are usually created when a property transfers through a family estate transfer. So it is not a situation where you work with a real estate professional to buy your home. Um, that is not a situation where you have to be worried about this. Almost always, when you go through a traditional home sale, you will have title insurance, you will have someone do a title search to make sure that when you are buying the property, that there is a clean title to it. So I want to go through some examples of where I see tangled titles created the most. And I do see that we have at least one question coming in through the chat. That is great. Please keep sending questions through the Q&A function. I will answer those at the end of the presentation. So I'd say the most common example of how a tangled title is created is when a property owner passes away without a will or another form of estate planning in place. We'll talk a little bit about other types of estate planning. Because a will is the most common type of estate planning, there may be times in the presentation where I talk about only a will. Just know that oftentimes you could do another sort of estate planning at that same place, and I will do my best to call that out as we go along. But if if you die and you don't have a will or estate planning in place, then your property is going to be transferred through what's called intestacy laws. So those are laws that are specific to each state, which says what is the default option of how property is transferred if someone doesn't put an additional plan in place. And those intestacy laws are not laws that are triggered automatically upon your death. You have to go through probate court or your state's version of probate court in order to transfer the ownership interest. Another common way that we see tangled titles created are when the property owner passes away with a will and leaves their property to multiple people. And then those owners' heirs who are named in the will never go to probate court to get the will validated and to get the legal ownership of the property transferred. This could also be a problem if you have a will that only names one person as your heir, but I put multiple people here in the examples because, as I'll explain going through, the tangled titles are the biggest problem when there are more than one heir. When there is just a sole heir, you'll still have to be going through probate, but it'll be an easier process to get things processed. And I do want to acknowledge that there are many reasons why you would name more than one person to be your heir in a will or in other types of estate planning. Property is very personal. It is an emotional decision. It is a decision based on lots of family choices. I am not trying to give you individual advice about what to do with your property. That is something that you have the right to decide. I just want to make you aware that if you're leaving your property to multiple people, you should consider some additional risks that might come with that if a tangled title is created. The last example here is when a property owner passes away with a will, they go through probate or the appropriate version, and the ownership is actually transferred to those multiple people. But then the new owners do not cooperate with each other, or maybe one of the owners passes away before they can get their estate planning in place. So then they have a tangled title at that secondary level of the new owner. I see this when there are multiple siblings, perhaps, that own a property. Maybe one of the siblings is not in communication with the others and they're not living at the property, they're out of state. So then the sibling who is living at the property is not able to work with their co-owners to get the protections they would need as if they owned the 100% interest in the property. Now, I think one of the most common questions that I get when I talk about tangled title is a tangled title created when I own a property with my spouse and my spouse has since passed away? I would say that that is a slightly tangled title. It is not going to cause the same sort of problems as you'll see in these other examples that I went through. So most often, and this applies in almost all states, when you are owning property with a spouse, you're going to own property under what's called a joint tenancy. And that is different than the default type of property ownership that we have in the country, which is called tenancy in common. If you own property with more than one person as a tenant in common, then your interest in the property passes through estate planning or through intestacy laws when you pass. It does not transfer automatically to the other co-owner of the property. If you own property as a joint tenant and you pass away, then your ownership interest in the property passes automatically to the other owners of the property. So that is often the situation when there are spouses. If your spouse has passed and their name is still on the deed, usually all you will need to do is record a simple affidavit, submit a copy of their death certificate to get their name taken off the deed, and then you're the sole owner of the property. You're not going to experience these issues I'm going to talk about with tangled title. Like I said, for married couples, joint tenancy is almost always going to be the default. If you're not sure whether that applies to your situation, you're going to want to look at your deed and you're going to see whether it says John and Jill own the property as joint tenants with rights of survivorship or some similar language. That will be your clue that you own it as joint tenants rather than tenants in the common. So why are we here? Why are we talking about tangled titles? It's because they can create quite a lot of problems for property owners and property owners' heirs in the future. One of the big problems is an increased risk of losing the home. I see this happen with foreclosures. If the heirs of the property or the homeowner who is living at the property falls behind on the mortgage, on the property taxes, then the lender will often file a foreclosure action. If your name isn't on the title, then you might not be able to get proper notice of when an action is filed. A servicer for a mortgage might not communicate with you about the loan as they would if your name was on the title, and they might refuse to give you the same sort of protections and options that would be available to a homeowner in a foreclosure who had a clean title. So let me give you an example for the cases that I work with. I have a client who came to me after she had a foreclosure filing against the property that she was living in. She had moved into the property a couple of years ago to care for her father as her father was dying from cancer, and stayed living in the property with her family after her father had passed. Their family experienced some financial hardships around the COVID pandemic. She fell behind on the mortgage, and there was a foreclosure filed. Now, her father actually had created a will that named my client and her two brothers as heirs to the property, but they had not gone through the process of getting the will probated and getting the property transferred to the three of them. So when she reached out to the mortgage servicer to ask what her options were to resolve the foreclosure, she was told that she would have to get the clean title before they would accept a loss mitigation application for her. So now she is doing both. We're both doing the probate. We're getting the will into probate court. We're getting the property transferred to her and her brothers. And then we'll get her brother's interest transferred to her. And then she'll be able to resolve the foreclosure. That just puts her in a more precarious situation because foreclosures can work on a different timeline than the probate court. Ideally, you want to get the probate court finished before there would be any sort of a risk of a foreclosure happening. Another big common reason why you may experience increased risk of home loss is because if you have a tangled title, it could reduce your eligibility for home assistance programs. So it can be difficult for heirs to get homeowners insurance in their name if they don't have clean title to the property. It can be difficult to apply for assistance funding if you have a tangled title. We saw this often with the money that was available from some of the pandemic bills that Congress passed, and each state created their own program for homeowner assistance. We're fortunate that some states, like Ohio, opened their programs up to people who had tangled title, and they were still able to get the same sort of assistance as they would have if the title to their property was in their name. But that didn't happen across the country. Some states, if you had a tangled title, you were barred from applying from those programs. That certainly doesn't mean that you don't have the need for these programs, right? If you are living in the home, you're acting like the homeowner in other regards, you probably have some of the same needs as homeowners who have a clean title to their property. We also see this with private lenders and grant makers, where they will require you to have a clear title to the property before you can get access to their funding. We see this in my practice as a particular concern when homeowners go to apply for home repair programs. Because of the nature of tangled title, that it is property that has been transferred from multiple generations, we're often dealing with older properties. Older properties, as I'm sure some of you know, are very expensive to maintain. And those are costs that my clients who are living on low fixed incomes can't pay out of pocket. So they would be great candidates for some of the home repair funding that we have available, but some of those home repair funds aren't accessible if you have a tangled title. I'll give you an example of one of my clients who inherited her home from her mother. Um, it has been in their family for a long, long time. And she owns the property right now as a co-owner with her 3 siblings. The home is over 100 years old. It needs a lot of repairs. So she was fortunate that she found a foundation who would pay a substantial amount of money to get the home up into habitable conditions, to make to repair some code violations that she had, and make it a better place for her to live, for her to age in place. But unfortunately, she had the agreement of 2 of her siblings, but the other sibling was MIA. They weren't in contact, and she didn't know how to reach them to see whether or not they would transfer their ownership interest in the property to her, because the grantor said that they would give her this money, but she had to be the only owner on the property. Her 3 siblings who weren't living in the home couldn't also be on the title. So that's a situation where we would consider that a tangled title because there are multiple owners and the owners aren't cooperating with each other. And in the end, at the moment, it has cost her this assistance that she would qualify for otherwise. A specific example of assistance that I just want to call out quickly is a decreased option for disaster relief funds. So sometimes when there are natural disasters, you will have to show that you have a clean title to get the funding for recovery efforts. After Hurricane Katrina, about 5% of applications were denied by FEMA because of title issues. Now, those FEMA, federal government, and some state governments have made some improvements since Hurricane Katrina. They will sometimes now allow you to submit alternative ownership documents to show that you have some ownership interest in the property, even if there is a tangled title still there, but that is not a guarantee. And of course, when you're recovering from a natural disaster, that is not the time to make things more complicated than they absolutely have to be. And these issues that put homeowners, put heirs at risk of losing their home also make heirs vulnerable to what I call the general term of equity stripping practices. So equity stripping practices, what I mean by that is anything that is going to result in the heirs or the homeowners receiving less than their fair share of the equity in the home. One way that we see this happen is predatory home buying schemes. So I'm sure that many of you have gotten those letters in the mail that say, all cash offer for your house. We will buy your house at this rate within a week or so, a very short turnaround. Um, Oftentimes, those all cash buyers are going to be offering you a lower price for your home than what you would receive if you went through a traditional home sale with a realtor listing it available for the full public. But if you have a tangled title, if you are in a vulnerable position, you might be struggling to keep up with the payments and don't have access to other assistance funds, you may be more likely to say yes to those all cash buyers, and you wouldn't get as much equity for that purchase as you would if you went through a traditional home sale. We also see this happening with probate advance companies. So this is different than the inheritance scams where you get a letter saying that you have a anonymous deceased far away relative who has designated you as their only heir. You just have to send in a little bit of money and your social security number and all your identifying information. What we're talking about when we're saying a probate advance company is companies that reach out to legitimate heirs and say, we will give you $10,000 in exchange for your interest in the assets of this estate. So say probate court can take often a long time. It can be a stressful situation. And sometimes you might need money up front. So those are the people who are vulnerable to these probate advance schemes. But almost always, similarly to the all cash home buyer, these companies are going to be offering you less money than you would have received if you had finished the probate process. Because right, they're trying to make money off of this. They're not going to offer you the exact same amount of money that you would make if you had waited out probate. So that's a situation where, again, you're losing equity in the home. And then the last part, or the last equity stripping practice, this one is a little bit more complicated. It's called a forced partition sale. So a partition sale is a process that happens through the courts when a co-owner of the property asks the court to either sell or divide a parcel, so a piece of property that is owned by multiple owners. If you're talking about maybe a big piece of farmland, then you might be able to partition the physical property itself so that everyone still gets a piece of the land. But when I'm talking to my clients, we're usually talking about a single family home. That's a whole lot harder to divide into fourths. So it usually results, instead of a partition of the land itself, you sell the property and you partition the proceeds of the sale. This happens, I would say, somewhat rarely if all of the co-owners are relatives, but where we see it happen more is if one of the relatives sells their interest in the property to a real estate speculator who is unrelated to everyone, often just looking to turn a profit. And then they will ask the court to force a sale of the property to get their monetary interest that is in the property. Usually, unless the other co-owners can pay off that person's interest, then the property would go to sale. And similar to a foreclosure sale, it's often not sold at the same level as you would get if you went to the general market. So the sale is going to produce less of an income. You're going to get less equity out of it. Partitions are also just particularly heartbreaking if there is a family member who is still living in the property and they have to be displaced because of the sale. I will say that we do not see partition sales happen a lot here in Cincinnati. I would be more worried about it for my friends on the call who are in Brooklyn, New York, Los Angeles, places where property is worth significantly more money, because there are costs involved here for a speculator. They're going to want to make sure that the property value is high enough that it is worth their time to go through a partition sale. So I don't want you leaving here thinking that it happens every day, but it is a consideration that we need to be mindful of when we're talking with clients about what are the best options for them. And all of that, the equity stripping, the loss of homes, it prevents the transfer of generational wealth. Because these homes are sold below market usually, because the homes will depreciate in value if you're not able to keep up with the maintenance because you don't have access to assistance funds you might otherwise qualify for. And that lack of generational wealth is going to frustrate the property owner's wishes. So I don't think anyone who owns property wishes a tangled title on their loved ones, on their heirs. That is almost never the wish of a person when they are thinking about what they want to happen with their property when they pass, which is why it's always important to go through that estate planning process. Even if you think you have a really simple estate, you want to make sure you have a plan in place. And on a macro level, what happens at the individual property level is going to affect neighborhoods. So Tangled Title has the possibility to destabilize neighborhoods if it's going to displace families who have been living there for generations, if it's going to lower housing values that will then affect neighboring properties' values. It could increase neighborhood blight. In general, it just can make it harder for people who are good residents of neighborhoods, who are been there for a long time, caring for their communities, to stay in those communities, to stay in their place of choice. And I can't finish talking about the problems of Tangled Title without mentioning that these problems don't affect us all in the same way. So we see Tangled Titles happen at a much higher rate in our minority and our Black households. And there's good reasons for that. Estate planning, legal planning is expensive. There's been generations of systemic harms done to our Black homeowners, our minority homeowners through the legal system. And there are good reasons for folks to be wary or distrustful of the legal system based on our history. Because of that, we see Black families and minority families often don't have the estate planning in place to prevent tangled title. So there is a higher rate of tangled title there. And then that perpetuates the racial homeownership gap. Nationally, the racial homeownership gap is about 30% between white families and Black families. In Cincinnati, I am sorry to say that we're doing worse than that. It is almost 40% in Cincinnati. And because homeownership is the main driver of wealth in our country, if we're talking about a racial homeownership gap, we're also talking about a racial wealth gap. So this has a generational effect for families. And particularly when we're talking about our AARP audience, tangled titles also disproportionately affect older adults. So there was a study done recently that says that the majority of heirs who are over 50 when they inherit property, and a quarter are over 61 at the moment of inheritance. This is a particular problem when it occurs for older adults because older adults are more likely to be losing out on some of those assistance programs that are designed to help seniors if they had clear title to the property. So maybe you won't be able to qualify for the senior property tax reduction in your state if you have a tangled title. So that are all the problems. That is the lay of the land. I do not want you to leave here and have a overwhelmingly gloomy disposition about this. We're now going to talk about ways that we can resolve tangled title, live with tangled titles, and prevent tangled titles. The first thing to do is to figure out if you have a tangled title. So the easiest way to do this is to look at your most recent deed for your property. You can find a copy of your deed in your local county public property records. For our Ohio friends, that's going to be your county recorder's office. You might be able to find that online, or you could almost always go down to their physical office, give them your name, tell them that you're looking to find a copy of your deed, and someone should be able to help you do that. A quick way to do that is also to look at your property tax bill. If you are getting your property tax bill directly to your house, it's not going to a mortgage servicer. You should be able to check to see who is listed as the property owner on the property. If it's listed as someone other than yourself, then you need to be aware that you might have a tangled title situation. So what to do if you think that a tangled title applies to you? And again, I want to just emphasize here that we are not talking about joint tenancies, about situations where you own a property with your spouse. That is, like I said, almost always not going to be a problem. And even if it is a problem, it's going to be a minor problem. So you want to find out who the legal owner or owners of the property are. Maybe it's you and your siblings, like my client I talked about before. Or maybe it's your mother who has since passed away. If it is someone who has passed away, then you're going to want to find out who are the owner's heirs. If the owner died without a will or other estate planning in place, then the ownership will pass through your state's intestate laws. Those are the default laws of how we transfer property between generations in your state. I'll have to get a little Ohio specific here because I am not familiar with the intestacy laws of other states, although I do think that they track fairly similarly for the overarching principles. If you have a surviving spouse, then your surviving spouse is going to almost always have at least a partial interest in the property. They might have a full interest in the property, depending on if you have biological children who are not the biological children of your spouse. Your spouse may also have a specific interest in the family home, which could sometimes be called the manor home, in addition to their rights that they would have to other assets in your estate. If you don't have a surviving spouse when you pass, then your property will usually pass to your biological children. And if your biological children pass away before they have their estate planning in place, then their interest in the property passes to their heirs. Because it's not like what I talked about, the joint tenancy, where it transfers to the surviving heirs, it transfers continually down the tree, heir by heir. And I do have to, I try and call out that it's often based on biological children because that's the way it is in Ohio. And I think it's an important thing for people to think about because biological children for many people doesn't actually encompass what you consider as your true family. The law is not always going to match what you think the family landscape is for your life. So that's another reason why you don't want to be relying on these default rules. You want to make your own estate planning. If the owner of the property is deceased, but they had a valid will or another type of estate planning in place, then the property ownership is going to pass according to the will. So it will pass to whoever is named as the heirs in the will. You will have to still go through probate court or your state's version of probate court to get that ownership transferred through the will. A will is not a document that is triggered automatically upon your death. There are some types of estate planning that you can use to transfer property outside of probate court. One of the most commons is a transfer upon death deed or affidavit. If you have one of those in place, then the property would transfer according to that legal document. So once you figure out who the heirs are, you need to decide whether it is worth to communicate with them, reach out to them. And I say this mostly talking now to people who are the ones who are living in the home with this tangled title problem. You have to decide whether it is worth it to reach out to your relatives who might have an interest in the property that you're living in, with a being mindful that they have an interest in the property, which means that they are a co-owner of the property, even if they're not the ones living in the property, and they could try to sell their interest in the property and get whatever money they have out of their portion of the property ownership. If you think that that is a strong possibility in your family and you don't have the funds right now to pay off that interest, sometimes I have clients who decide that it is better to not untangle this title, that it's better to keep living at the property but not communicate with the heirs because they're worried about displacement from the home. But if that's not you, if you think that like the client I mentioned before with her two brothers who they were all working together, if that's your situation, I would recommend reaching out to the property owners or to the other heirs. You still want to try and come to an agreement before you move too far into the formal probate process. You also want to consider what other assets and liabilities the property owner had that would be included as assets and liabilities of an estate. So did they have cars? Did they have a bank account, a retirement account? If they had those types of accounts, were they transferred from a beneficiary or are they still in that person's name? For liabilities, you need to consider if they have other debts that might have creditors who would come in and say, we need these credits to be paid from the assets of the probate estate. Some of the debts might be time barred if the estate hasn't been opened in a certain time after the owner's death. So that's a situation where you'd want to be consulting with an attorney for your estate. The liability that I am most concerned about for my clients are usually what's called Medicaid estate recovery. I'm not going to get too in the weeds with Medicaid estate recovery because AARP Ohio will have a whole session about Medicaid estate recovery later in the year. But what I'll say here is that if you are receiving Medicaid, then there is a federal law that the states are required to enact to try and recoup the costs that Medicaid paid for your health care from your estate. In our situations, that usually means they're trying to recover those costs from your house, from your property. Healthcare is very expensive. These claims can be in the 5 figures and the 6 figures. And if you don't fall within one of the statutory exemptions in your state for to be exempt from a Medicaid claim, to have the Medicaid recovery claim waived, and you don't have the funds to pay the claim, then that's a situation where you might say it's actually not worth untangling this title because I don't have the funds to pay that claim that I know would come as part of the probate estate. And I want to keep my house, keep my stable housing more than I want to get the clean title. That is a very fact specific situation. The different exemptions and waivers vary by state, but I want to make all of you aware of that because it is a question that we get a lot. And because I think it's a situation where we need some more education on, which is why I'm really grateful that AARP Ohio will be having a session about Medicaid estate recovery because it can often be scary and it's something that we oftentimes homeowners don't know very much about. So then if you decide to go ahead and resolve the tangled title, you'll want to follow your state law to transfer title through the appropriate method. That might be filing an estate with your county probate court. That would be the situation you would want to go through if there was no will or estate planning and you're transferring title through the state's intestacy laws, or if there was a will, because the wills need to be gone through probate court before the property can be transferred. or you'll want to follow your state's laws to transfer property outside of probate court. I'll give you two examples of how this has worked for my clients. So I had a client who came to me. He was living in the home that was still in his mother's name, and he wanted to get the title into his name so he could access a mortgage assistance program that he qualified for. His mother had died without a will. My client was her only son, and she wasn't married when she passed away. So even though the property owner, his mother, died without estate planning, under Ohio's laws, it was a simple transfer through the intestacies laws. Because he was the only child, he received 100% interest in the property. We helped him file a probate estate. The probate court recognized his interest and transferred 100% ownership interest in the property to my client. He now has the deed in his name. I have another client who came to me looking to get title to the house that she was living in. The title was still in her mother's name, who had passed away several years ago. Her mother had created a will, and in the will had named my client and her 3 siblings as heirs. There was also a Medicaid estate recovery claim because her mother had been on Medicaid before she passed. So in that situation, the first thing I did was work with the Ohio Department of Medicaid to get that Medicaid claim waived. Because fortunately, my client qualified for one of the exemptions that could waive the Medicaid claim. Next, once we knew that that liability was not hanging out there, my client talked to her siblings to see what they wanted to do with the property. She was the only one living at the property. Her siblings had their own houses. They had stable forms of housing. So they were okay with giving my client their interest in the property, but they did want to receive some sort of compensation for their interest. So they came to an agreement that they would go through probate. At the end of probate, they would be co-owners of the property because probate is going to transfer the property according to the will, which named them all as owners in equal parts. And then outside of probate court, the siblings and my client will do deeds. So the siblings will deed their interest in the property to my client. My client will work out a loan situation with her siblings to pay them back over time. And then she will have 100% ownership interest in the property. She'll be able to make the home repairs that she needs. So that's a good example of working with your siblings, having good family cooperation, be able to resolve a tangled title. But sometimes it is not possible to resolve a tangled title. So then we turn to living with a tangled title. How do you minimize the risks of the problems that we talked about in the first half of the presentation? One of the most important things I tell people is to continue paying the bills. So if you're the one living in the property, I always recommend that you continue to pay the mortgage, you continue to pay the property taxes for as long as you're able. As you're paying these bills, you'll just want to be mindful of the fact that you are paying at that point more for a stable place to live than to use the house to build that generational wealth. Because in order to get that access to that generational wealth, you will likely have to untangle the title, which you at this point have decided was not a good choice for you. But oftentimes, it is still cheaper to pay to live there than to try and rent someplace else. And that's setting aside the often very important emotional and family connections to a house as well. So when a client is living with a tangled title, I tell them to continue paying the bills, but think of it more as you would as if you were paying rent than if you were paying a mortgage or property taxes because you might not receive the same payoff as you would if you had 100% ownership in the property. The other thing to do if there's a mortgage on the property is you're going to want to ask the mortgage servicer to become a successor in interest on the loan. So successor in interest is a legal term of art that creates a classification that gives heirs and homeowners who acquired their interest in the home through a death or a divorce or another type of transfer of rights, certain privileges when they're talking to the mortgage servicer without having to assume the personal liability for the debt. Successors and interest, once they are confirmed, can communicate with the mortgage servicer as if they were the borrower. So this means that they will be able to pay the mortgage, they'll be able to get information about the mortgage, and they'll also be able to apply for loan modifications or loss mitigation options if they fall behind on the mortgage. Now, servicers may require the homeowner to assume the mortgage to accept a loan modification or a loss mitigation option. And if that happens, then they often will need to resolve the tangled title, but you should at least be able to apply without doing that if you're a confirmed successor in interest. Different mortgage servicers have different requirements for what you need to submit to them to become a confirmed successor in interest. The federal government has like a reasonableness standard for what documents a servicer can require. They will almost always want to see the death certificate of the person who is named on the mortgage and your relationship to the person who is named on the mortgage. If there is a will, they're going to want to see the will. If there's another type of estate planning document, they're going to want to see that. Sometimes they will want to see probate court documents. So something that says that you were named as the administrator or executor of the will or of the estate. Sometimes they might be able to do an heirship affidavit. It really will depend on the specific mortgage servicer, but those are some examples of what I see most commonly. And then you're also going to want to, regardless of whether you have a mortgage or not, you'll want to apply for any assistance programs that you do qualify for. It's going to vary pretty widely based on your state, based on even your city, what assistance programs you qualify for with the Tangled title. But you do want to at least put the feelers out there, research, and see if you qualify. Like I said before, in Ohio, for example, our COVID assistance funds for homeowners, you were able to access with a Tangled title if you submitted some additional documentation. And then you're going to want to look at whether your state provides protections for heirs. One of the more common types of protections is called an heirship affidavit. So an heirship affidavit is an affidavit, which means it's a sworn statement that you sign that identifies the heirs of the inherited piece of property. These are usually recorded in the property records of your state. So they will put other people on notice that you have an interest in this property. Depending on your state, they may transfer the ownership interest entirely. In Ohio, they do not do that. So that is another situation where you're going to want to look at your state-specific laws. If there are other heirs out there who aren't living at the property, it might be worth looking to see if your state is adopted with the Uniform Partition of Heirs Property Act. The Uniform Partition of Heirs Property Act is a state law that protects heirs from losing their home through a partition sale. So it gives heirs additional rights before a partition sale would be completed. It makes sure that all co-owners of a property have notice that someone has requested a sale. It requires the court to get an independent appraisal of what the market value of the home would be. It allows other heirs to have the opportunity to buy out the person who is asking for the sale's interest in the property before it would go to market. And then if this property is sold through market, there are protections to make sure it is a fair price. The Uniform Partition of Heirs Property Act has been enacted in 23 states. It has not yet been enacted in Ohio, and it's also been introduced in a couple of more states beyond that 23. So we're hopeful that this will be continued to be adopted from other states. And then you also should just be aware of adverse possession. You might have heard this term. It is a legal doctrine where a person who is living or possessing a property can get clear title to the property against other people who have an interest based on their type of possession of the property. Adverse possession is one of the probably one of the most state-specific things I'm going to talk about tonight. This is a situation where you need to consult an attorney. It is not only state-specific, but it can be property-specific. It's a very fact-dependent inquiry about whether it applies to your situation. I will say it is almost across the board a slow process. So for example, in Ohio, you have to have possession of the property, exclusive possession of the property for 21 years before you could get title to the property through adverse possession. And lastly, even if you're not going to be resolving the tangled title, that doesn't mean that you're off the hook for doing your own estate planning. You still want to make a plan for passing on your assets to your loved ones when you're gone, so the title does not become even more tangled after you die. How to prevent a tangled title. It is a whole lot easier if you're able to prevent this problem than trying to unravel it once it's already occurred. We've talked a lot about estate planning, or at least referenced the importance of it. But before you get into estate planning, I think that the primary or the first step is to think about how you want to use your property. What is the primary goal for your house? Oftentimes, if you're doing estate planning, the default setting is going to be assuming that you're using your property primarily for creating generational wealth. So this is a situation where maybe you don't have a spouse, but you have a couple of children. Your children are all in a pretty stable situation. They had their own housing, and you don't think any of them are going to want to live in your house when you're gone. They're going to want to sell the house and distribute the proceeds between them. That might be a situation where it's unlikely that a tangled title will be created because the house will be sold, and you could be okay with just distributing your property in equal shares to all of your children. But if you think that there is a person in your family who is going to need to use that property as a source of stable housing, I always counsel my clients to give serious thought to whether they should leave their property exclusively to that person. So I see this happen most often for clients who have maybe a couple of children, but one of their child is disabled and they're the ones living at the house with the property owner. They're not going to be able to find other housing on their income. And in that situation, you might want to consider leaving the home only to that child to prevent that child from having to deal with a tangled title in the future. Of course, there are many different considerations that I'm sensitive to about that, but I think this is a first question that some people miss. So that's why I always say, consider what type of estate planning you need to achieve your primary goal of how you want your property to be used. After you do that, then you can pick what type of estate planning fits your needs best. That could include a will, A will, I would say, is the most common type of estate planning. It's a legal document that describes what you want to happen to your assets when you pass away. You'll need to go through probate court or your state's version of probate court in order to transfer the property and the assets through the will. Every state has a little bit different requirement for what you need to do to make a valid will. For example, in Ohio, you need to have 2 witnesses who are not interested parties in the will sign the will at the same time that you sign it to have a valid will. So I would, again, recommend that you look at your own state's laws. I would say the most common way that I see to transfer property without probate court is a transfer upon death deed. That's also called a transfer upon death affidavit. That's a document that you record in your property records. It'd say when you die, you want that your property to go to a certain person. And then once you die, the person that is named has to submit usually another short affidavit. In Ohio, it's usually called a survivorship affidavit, and the death certificate into the property records, and the property is transferred automatically without having to go through probate court. You could also consider a life estate. A life estate is a type of property ownership where you transfer the property to someone else with the condition that you're able to remain in the property and possess the property for your lifetime. So you act as the property owner until you die, and then the property ownership transfers automatically to the person that you've named. We'll say when you consider a life estate, you want to, of course, be mindful of the person that you're choosing to have the property after you pass. And then also mindful of the fact that you can only sell what you own. So if you have a life estate, you only own the property for your lifetime. That could limit the types of usually loans that you would qualify based on equity in the property. And then there are trusts, living trusts. Trusts can be structured a lot of different ways, but in general, they are a legal document where you transfer ownership of a property to a trust, and then you designate a trustee to manage the assets in the trust according to your wishes. After you pass, then the beneficiaries of the trust could get the property ownership without going through probate court. I will say trusts are not something we deal with a lot in legal aid because they can often be expensive to maintain. So you'll want to have the resources to be able to pay for the maintenance of the trust. All of these situations, again, just consult an attorney before you decide what's best for you. If you can't afford an attorney, reach out to your local aid organization. So I hope this has been helpful for you. I am, again, grateful for everyone for staying on. Here is my contact information. I am with Legal Aid Society of Southwest Ohio. This is our general intake number. If you are someone who lives in Southwest Ohio, this is the best number to call to get connected to an attorney if you have a tangled title problem. If you are outside of Southwest Ohio, I believe we'll be sharing resources for you in the chat of how to contact your legal aid organization. And again, thank you to Nicole and AARP Ohio for sponsoring this presentation.
Awesome. There we go. Great. Thank you, Stacy. Okay, do you have time to hang on for a few minutes past 8:15? Because we have 23 questions. Now, I can't promise we'll get through all 23 questions, but we'll get through as many as we can. And so also what I put in the chat for you are links to help you find your legal aid near you, and then also a national resource about tangled title properties from the National Consumer Law Center. That link is also in there about property tangled title. So now let's go to the questions. I believe you also can see the questions, so I won't read it in its entirety. I'll just cue it up and you can take it from there. The first person is asking about the loan number on the deed at the county. It's different. What should they do?
So so I would contact your loan servicer. Your servicer should be able to tell you who owns the loan if it's someone who's different than the servicer of the loan. You're also going to want to look at go to your county recorder's office or whatever version of recorders you have in your county. Tell them the problem. That is where I would start. See if you can find where that discrepancy is coming from. Although it does look like I'm going to have to give you the unsatisfying answer that this sounds like a question for an attorney. I would consult your local legal aid organization or another attorney in your area.
Okay, and then Dale is asking a pretty general question about who can access legal aid services. Is it income based?
Yeah, so that's a good question. Almost all legal aids are income based, but it depends widely on what that income limit is. I can speak for Legal Aid Society of Southwest Ohio. We have one income limit for general intake. It's about 200% of the federal poverty level for your household, but we have a higher income level for homeowners because we recognize that homeowners might have a slightly higher income than that, but they still need legal help and they still can't afford to pay a lawyer. So I think it's worth looking into your local organization. For our Ohio friends, I'll also call out Pro Seniors. Pro Seniors is a great resource for Ohio. They will provide free, brief legal advice for Ohio seniors, regardless of their income level.
Great, thank you. So through all of these questions, we have a number of transfer on death questions. So to the degree you can answer multiple questions, that would be great. So leaving a transfer on death property to multiple people, does that create a tangle title?
I would say yes. If there's not a plan within those multiple people to what to do with the property after it is transferred into their name. So that goes to like some of the examples that I shared about situation where there's multiple owners. Maybe one owner is no longer involved in the property, the other people can't access them, and then there are problems. It really depends on your family situation. It depends how confident you feel that the people you're naming as the in the transfer upon death affidavit will get along and do the same things.
Okay, and if the property is transferred via quitclaim deed, is that creating a tangled title?
No, well, no, assuming that it is, again, the same caveat that I just said about if it was transferred to multiple people. A quitclaim deed is a type of transferring of property interest, so it's self-executing. If you execute a quitclaim deed, that the ownership is going to be transferring automatically.
Okay, and if you have a trust and a will, but part of the estate is not in the trust, does the part that's not in the trust have to go through probate?
Say that once more.
Yeah, so if the person has a trust and a will, part of the
Mhm.
estate is not in the trust. Does the part that is in the trust have to go through probate?
Probably not, but you're going to want to look at the specifics of the trust because trust can be, that's one of the benefits of trust. They can be tailored to your specific situation.
Okay, so what about when multiple siblings inherit the property via a trust and they don't agree on the sale of the property? How do they handle that?
So if the siblings who don't want to sell the property have the financial resources to pay out the siblings who want to sell the property, that would be the easiest way to handle it. Um, Oftentimes, when I'm dealing with my clients at legal aid, they don't have those resources available. That's when you're going to be at risk for a partition sale, like I talked about.
Okay. And so everything we've been talking about today, does that apply to land ownership?
Yes.
Okay. There you go, Faith. All right. So I've recently seen several articles about title scams, where people somehow apply to get their names on the title. How do you lock or out a scammer or prevent that?
Yeah, I have heard about that too. So I think the same sort of advice that you get about preventing other sorts of scams, you want to do your independent research, verifying who the person contacting you is. I think AARP actually has some good resources about that, so I would look at that website. But it is the same sort of advice for general scammers.
Thanks for queuing that up. Yes, so
Yeah.
John, feel free to go to AARP Fraud Watch Network. That's aarp.org/Fraud Watch Network. And in there is a fraud resource center by topic. I'm sure there's something in there about housing and property. I hope that's helpful. So where do I file the record affidavit to remove my deceased husband from the loan?
So if you're in Ohio, you're going to want to go to your county recorder's office. If you're not in Ohio, you're going to want to go to whatever government office keeps your property records.
Okay. My grandmother passed away in 2021, and the heirs were 4 adults, and one lived with her until her death. They never produced a will to us, but somehow she and her husband have the deed. How do they maintain their rights to their interests?
So if they think that there was a fraudulent transfer of the deed, that is certainly a situation where you're going to want to consult an attorney. If they think it's criminal fraud, you're going to want to report that to your local government prosecutors.
Okay. And Karen is the executor of her mother's estate. The title is in my father's name. Her father's deceased. But he left the home to her mother. The title to the home never transferred. The mother has just passed, and her will has been probated. The daughter is the sole executor, and the home is going to be sold soon. Does the daughter, does she have to have the title changed to her mother's estate? And if so, how does she do that?
So it's hard for me to tell you how to do that without knowing where you are located. I would say if you're already in probate court, the court is going to give you the best advice on that. It might need to be transferred to your mother's estate. You might be able to sell it without doing so if you know that you're already going to sell the property.
Awesome.
Also consult a realtor if you're going to be selling it.
Okay. If the real estate property is transferred by quitclaim deed by mistake prior to death, it has 2 names on it as the owners of the property. How can it be reversed?
It's going to depend on what type of mistake it was, whether it was a mistake that affects the validity of the transfer, then you might have some recourse. If it was just a mistake, but it was a legally valid transfer, and it wasn't like a fraudulent mistake, I think you're going to be very limited with your options. You might not be able to reverse that.
Okay. What if only one spouse's name is on the deed and we need help to keep it that way for now due to other reasons not explained? Can people just create a will and will it to the surviving spouse who is not on the deed?
Yeah, that's fine.
Okay. Let's see here now. You had mentioned a situation about 3 siblings. This person has a similar situation. There are 4 people, and her sister never gave them the 3 options of being the homeowner. We lived in the house. The house is 100 years old. What should they do?
So do the steps that we were talking about as far as resolving the Tangled title. Start with thinking about whether you're able to come to an agreement with your siblings. If you are, start reaching out to them, make preparations for, it sounds like you'll be going through intestate law in your state if there's not a will. You're going to want to consult an attorney for that. If you don't think you can come to agreement with the siblings, then you'll want to go through the steps that we talked about with how to live with the Tangled title. Make sure that you're getting the protections and the assistance that you're entitled to, even if you're not the only one on the deed.
Okay. This person is saying my father is in hospice and has a transfer on death for his house to be split between her and her brother. He lives out of state and isn't interested in the home and is fine with it going to me. What do we need to do to get the home solely in her name?
First of all, I'm sorry to hear about your father in hospice. I think I consult an attorney specifically for your state. I always have to keep saying this when I'm answering these individual questions. It sounds like you may need to record a new transfer upon death affidavit that names you as the sole heir. If that's not possible in your time frame, it sounds like if your brother is cooperative, you might be able to do a quick claim deed from him to you after the property is transferred according to that transfer upon death affidavit.
Okay, great, thank you. So my husband lived in the home when we got married. My name's not on the title. What is the best way to add my name without paying a fortune?
Oh, I think that is another one that I mean, I would consider consult your state laws. A quick claim deed from your husband to you and your husband as a joint tenancy with rights of survivorship might work. Again, you'll want to consult to make sure that there's no other implications with your estate and your specific situation.
Okay. What would you suggest for a husband and wife who wants to leave a daughter and son their home and their will? How can we prevent tangled title but still leave both children in the house and the will? I think you might have already addressed this, but go ahead.
Yeah, I think it depends if whether you think one of the children is going to want to live in the house. If they're not, then I would say that if the house is going to be sold, there's not a real problem in leaving the house to both of the children in the will. If you do think that one of your children is going to want to live in the property, you're going to want to have conversations with both children before you pass to be able to set a plan in place for the person who will be living there to continue living there. Ideally, transfer the full ownership to that sibling.
Okay, I believe you've also addressed this other question, but if there are two names on the property deed, can one of the owners leave their half of the property to someone else?
It depends on what type of ownership it is. If it is ownership, tenancy in common, so tenants in common, then they can do that because the property will pass like in two lines based on the two owners. But if it's a joint tenancy, like it usually is with a married couple, the in interest is going to transfer to the other person who's on the deed automatically upon the person's death.
Okay, and earlier you mentioned, I believe you were speaking to Ohio law, but I'll let you clarify about property passing to biological children. So this person has a question about, is an adopted child, I don't think she meant to say consider your biological child, but consider your,
Yeah.
yeah.
I mean, I would consult your I would consult your laws. Oftentimes it will be legal children, so it could be adopted children as well as biological children. Um, where I see it come up more frequently is like stepchildren, who you consider your children in every other way, but legally they're not the same.
Okay, if the property is listed in a trust, does that avoid probate and make it easier on the descendants?
You're going to want to consult what your specific trust says, probably.
Okay, so this is pretty long. So we sometimes see an attorney acquire a vacant property where the owner is deceased, and they find someone, often a distant relative, who is willing to sell it with an attorney for a nominal price. And the attorney then sells the property using that quick claim deed, and typically no title search was done. The buyer then assumes all due taxes and any unknown liens. Is that legal? Does the buyer have any recourse to resolve these liens?
So whether it's not it's legal, you're gonna want to. I would need a little bit more information. I would need to know what state you're in and all of that. If there's any recourse, I would refer to the Uniform Partition of Heirs Property Act that I talked about, if that's enacted in your state. And this was when you're saying a sale of the property, it was sold through a partition sale. There might be some protections that the other co-owners have available to them. Um, as far as resolving the liens, I mean, general rule is that you buy a property, and if there are liens on the property, then you're buying the property with those existing liens. So,
Uh, can a closed probate case be reopened? It sounds as if this person wants to reopen that case.
I would consult your specific state laws. It maybe if there is an error, but I can't give any more specifics about that.
Okay. Okay, I'll just read this. It says there's no will no kids, no spouse, no living parents, but there's one sibling who lives in the house. How should I go about getting the property transferred?
Assuming that the person speaking is the property owner right now, I would make an estate plan that transfers the house to your sibling who you want to live in the property after you're gone, or continue living there. If the sibling is living in the property and the person who's on the title is deceased, you're going to want to go through the steps I talked about whether your state's intestacy laws apply or whether there was any sort of estate planning besides a will.
Okay, well, we got through them. Thank you. This has been an awesome time with you, Stacy. I want to give you a moment to just say a few words before we let you go, and then I'll share some more information with our audience.
Yeah, I want to thank everyone again for staying with us this evening. I think that being on this webinar is a great first step for preparing to avoid these problems in the future. I think preparation is key. You want to think seriously about what type of estate planning fits you. If you are in a situation where you have a tangled title, I gave you some general information that I hope is helpful, but you're also going to want to consult an attorney about your specific situation. Use those resources to find a legal aid attorney if you qualify, or find another attorney in your area.
Awesome. Thank you so much, Stacy. It's been wonderful working with you. You've been a wonderful resource.
Thank you.
All right, we'll let you go now. And before we close, I do want to share a couple of ways to engage with AARP. You can turn a lifetime of experience into the experience of a lifetime. You've seen several of our AARP volunteers engage with you through chat. And so you can become an AARP Ohio volunteer and help protect the rights and well-being of people ages 50 plus by working on issues such as fraud prevention, supporting family caregivers, helping to make homes and communities more livable for people as they age, engaging voters, and advocating for beneficial policies at the local, state, and federal level. You can enjoy sporting, cultural, and community events, and whether you can spare a few hours or commit long-term, you can make a difference and new friends too. So AARP offers both remote and in-person volunteer opportunities and provides training and support to enhance your experience. To learn more about volunteer opportunities in your area, you can visit aarp.org/I-want-to-volunteer. That's volunteer opportunities in your area, no matter where you are in the country. You can visit aarp.org/I-want-to-volunteer. And finally, AARP is local, right there in your area, offering meaningful connections and enriching experiences close to home. To find AARP events near you, visit aarp.org/local. That's aarp.org/local. And as Stacy mentioned earlier, we will be having a webinar on Medicaid estate recovery on August 14th. We'd love to have you join us. You can sign up at aarp.org/Ohio. That's aarp.org/Ohio, Medicaid estate recovery on August 14th. It's been a pleasure being with you today. In a few minutes, you'll receive a survey about this event. Please complete the survey to help us continually improve our offerings. Thank you for joining us and staying with us a little longer. We hope to see you at another AARP event. Good night.